No, why so much time? I don't understand. All right, let it be there. Now, I take his words and then proceed with the case. Come on, argue.
Please, madam.
ಸುಮ್ನೆ ಅದಕ್ಕೆ ಒಂದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಗೆ ಅದಕ್ಕೆ ಇಷ್ಟೊಂದು ನೀವು 30ನೇ ತಾರೀಕು ತನಕ ಕೊಡಿ ಅಂದ್ರೆ ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ನೋಡಿ ಇವ್ರೆ ತಾವು ಕರೆಕ್ಟ್ ಆಗಿ ಇರ್ತಕ್ಕಂತ ಇದನ್ನ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಮಾಹಿತಿನ ಸತ್ತಿದ್ದಾರೆ ಬದುಕಿದ್ದಾರೆ ಅಂತ.
My lord, short question involved, my lord. There was a reference was made, my lord. In the reference, my lord, the person who is entitled for, my lord, the claim of the amount was to be determined. A portion of land was acquired, my lord, say, an area of 8 cents. The appellant herein was the owner of the possession and of the land in dispute, my lord. Her name was appeared in the award and, my lord, all revenue records. On the basis of that, my lord, my lord, before the claim petition, my lord, reference court, the evidence were read. And, my lord, the ultimately, my lord, the LAC court holds that, my lord, the compensation amount has to be awarded to the claimant number 1, that is the respond number 1 herein. My lord, on the basis of a document, my lord, alleged to be executed by the appellant herein, my lord. My lord, that finding was taken in appeal before the appellate court under section 54 of the Acquisition Act. My lord, the appellate court erroneously holds that, my lord, my appeal is not maintainable and dismisses the appeal on 2 grounds, my lord. One is that the appeal is not maintainable before the appellate authority. Secondly, my lord, there was a delay of 13 days in filing the appeal, and therefore on that ground, my lord, the appeal was dismissed. That order is
What is the document that you executed in favor of the first respondent is the only question. It was a
Yeah.
30 reference.
my lord, whether, my lord,
30 reference, the trial court has come to the reference court has come to the conclusion that whatever the rights that you were possessing, it has been settled in favor of the first respondent. That is the finding.
that is erroneous finding is because, my lord,
That is, everything is erroneous according to you, but
Yes.
let us see what it is.
my lord, exhibit, my lord, the P2, if looked into, my lord, that is the document they want to rely. Where,
They
my
have
lord,
relayed, not want to relay, they have
yes,
relayed.
my lord, that
There is a discussion.
survey number 21/1B is not at all forthcoming in that document, my lord. My lord, the land sold under the exhibit P2 is lands fell to the share of the, my lord, the appellant in a registered partition deed. There is a reference in the exhibit P2 that what was sold is lands which are fell to her share by virtue of a registered document.
What is the land survey number in the partition deed?
My lord, the land sold under exhibit.
Please tell me, don't say lands.
Yes.
Let it not be an unknown. One unknown, you cannot define it by another unknown.
Yes.
Please tell me what is the partition deed, what is the land that was in the survey number, and what has gone to them, sold to them.
Yes,
Please tell me the number.
please, my lord. My lord, the exhibit P2 is the sale deed, wherein, my lord, only clarification, my lord, acquisition
ನಿಮಿಷ
is,
ತಾವು ಅದನ್ನ ಕೇಳಿರೋದೇ ಆ ತರ ನಿಮಗೆ ಗೊತ್ತಿದೆ 30 ರೆಫರೆನ್ಸ್ ವಜಾ ಆದ್ರೆ ಏನ್ ಅಪೀಲ್ ಹಾಕ್ಬೇಕು ಅಂತ ತಮಗೆ ಗೊತ್ತಿದೆ. ಇಟ್ ಇಸ್ ಟು ಬಿ ಟ್ರೈಡ್ ಆಸ್ ಎ ಸೂಟ್. ನೀವು ಎಮೆ ಹಾಕೋತಿದ್ದೀರಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಮುಂದೆ, ನಾನು ಅದೆಲ್ಲ ಬರಿಬೇಕೇನು?
ಅಲ್ಲ, acquisition of the,
ನಾನು ನಿಮಗೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಅದನ್ನ ಉತ್ತರ ಕೊಡಿ ಪ್ಲೀಸ್.
the lands are referred to under the registered partition deed, my lord, 26/20, 26/27, 26/23, 26/21, 26/22, 26/26, and 16/19, and 26/19. My lord, whereas the present land in dispute is 21/1B, my lord.
Correct.
It's not part of either the sale deed nor the partition deed, my lord. But, my lord, all reference document speaks that, my lord, as on the date of acquisition, this 8 cents of land was in the name of Sulochana Rai, that is the appellant herein. My lord, notice of under the land acquisition was also issued in the name of the appellant herein, my lord. My lord, one aspect.
It all about the southern boundary where it has been shown as the road. You will get the discussion in para 10.
My lord,
The other day also I pointed out, you can read para 10 for your satisfaction. Internal page 13, ink page number 36, 6 lines or 8 lines from the bottom.
reference court order, my lord. reference.
Yes, that's it.
Please.
That is where you get the discussion.
Then I am of the view that entire 21/1B has been purchased by.
When it
claimant.
is shown
Please.
to the court that on the western and northern side of the property purchased by the claimant number 1,
There
there
exists
exists a road
which is
60 years old as admitted by RW1.
One.
Then I am of the view that the entire survey number 21/1/B has been purchased by the claimant number 1 under exhibit P2 sale deed, unless you seek the rectification, correction, cancellation, whatever it is with regard to exhibit P2, which is the document of 1980, in a 30 reference, you cannot claim fraud has been played, my property has been taken. Yes, heard Shri.
Only one submission may I make, my lord. Only one submission.
ಹೇಳಿ
Just for my satisfaction, my lord.
ಹೇಳಿ
My lord,
ಶಾಸ್ತ್ರಿಗಳೇ ಯಾವತ್ ಬೇಡ ಅಂದಿದ್ದೀವಿ ಹೇಳಿ.
If survey number 21/1B, my lord, was part of, my lord, either the partition deed or, my lord, the sale deed, my lord, I would not have
Hey,
persuaded.
30 reference is not the suit to look into all those aspects of the matter. Please understand the scope of 30.
Yes, ma'am.
Scope of 30, there must be a bona fide dispute between the two persons with regard to the title to the property. You are assailing a sale deed of the year 1980 in a 30 reference. That is impermissible. Hard Shri Shatri.
My lord,
What's your good name, sir?
Ravi Prakash. Yes,
my lord,
sir.
now the
Ravi Shankar
reference
Shatri and
has given a
Shri
declaration.
Ravi Prakash.
My lord, one submission. My lord, reference court has given a declaration to the entire extent of land, my lord, now. My lord, 8 cents was acquired in the,
Sir, you know what to do if the particular finding is incorrect. You know what to do. Second appeal is by the claimant number 2, Srimati Sulochana N. Rai, challenging the validity of the order passed in LAC number 18/2006, confirmed in MA 1/2016. Full stop. Next, for facts in brief, which are at most necessary for disposal of the appeal, are as under. Who is the authority who acquired? Special Land Acquisition Officer, Karnataka Housing Board, Kaveri Bhavan, Bangalore, acquired the land in survey number 21/1/B. Full stop. In respect of compensation, payment of compensation is concerned, there were differences between the claimant number 1 and claimant number 2, namely Sitaram Bhatt and Srimati Sulochana,
Sita Ratna.
whereby
Sita Ratna.
Sita Ratna, sorry, Srimati Sita Ratna K. Bhatt and Srimati Sulochana N. Rai. First, therefore, the land acquisition officer deposited the amount before the civil judge senior division Bantwal, and parties were relegated to reference under section 30 of the Karnataka, 30 of the Land Acquisition Act, which was registered in LAC number 18/2006. Full stop. Next para. The learned trial judge, after receiving the necessary, after completion of the necessary pleadings, held an inquiry. Full stop. Next para. Claimant number 1 based her claim on the basis of the title deed, namely, on the basis of the sale deed, namely exhibit sale deed, which is marked as exhibit P2. First, power of attorney holder of power of attorney na Yajman Rao,
Allah Maga.
power of son of the first claimant, being the power of attorney holder, got examined himself on behalf of the claimant and placed on record 15 documents. First, as against the which were exhibited and marked as exhibit P1 to P15. Next para. As against the evidence placed on record by the claimant number 1, second claimant got examined through her power of attorney, namely Sharat Rai, who is also the son,
please.
son of the second claimant, who is also son of the second claimant, who is also who is son of the second claimant, and placed on record 4 documents which are exhibited and marked as.
Only clarification, my lord, acquisition is.
ನಿಮಿಷ, ತಾವು ಅದನ್ನ ಕೇಳಿರೋದೇ ಆ ತರ. ನಿಮಗೆ ಗೊತ್ತಿದೆ 30 ರೆಫರೆನ್ಸ್ ವಜಾ ಆದ್ರೆ ಏನ್ ಅಪೀಲ್ ಹಾಕ್ಬೇಕು ಅಂತ ತಮಗೆ ಗೊತ್ತಿದೆ. ಇಟ್ ಇಸ್ ಟು ಬಿ ಟ್ರೈಡ್ ಆಸ್ ಎ ಸೂಟ್. ನೀವು ಎಮೆ ಹಾಕೋತಿದ್ರಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಮುಂದೆ, ನಾನು ಅದೆಲ್ಲ ಬರಿಬೇಕೇನು?
ಅಲ್ಲ, acquisition ಆದ
ನಾನು ನಿಮಗೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಅದನ್ನ ಉತ್ತರ ಕೊಡಿ ಪ್ಲೀಸ್. If the 30 reference is dismissed, what is the proper remedy, sir?
Please.
Could the MA would have been maintainable? It should have been RA, no? Depending upon the value. It's a regular appeal. It is like a suit. Is it not? ಅದ್ರಲ್ಲೆಲ್ಲ ಏನು ಕೊಡಕ್ ಬರಲ್ಲ, ಅದನ್ನೆಲ್ಲ ಬಿಟ್ಬಿಟ್ಟು ಮುಂದೆ ನೋಡೋಣ.
ಆಯ್ತು ಸರ್, ಅಲ್ಲ ಒಂದು ಫ್ಯಾಕ್ಚುಯಲ್ ಇದನ್ನು ಹೇಳಿದಷ್ಟೇ.
ಫ್ಯಾಕ್ಚುಯಲ್ ನೀವು ನೋಡ್ಕೊಂಡು ಪ್ರೂವ್ ಮಾಡಿ, ನಿಮ್ಗೆ ಕೊಟ್ಟಂತ ಇರ್ತಕ್ಕಂತ ಜಾಗ ಎಷ್ಟು, ಅಕ್ವೈರ್ ಲ್ಯಾಂಡ್ ಎಷ್ಟು, ಏನೇನ್ ಬಂದಿದೆ ನೋಡ್ಕೊಳ್ಳಿ. ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಇರುತ್ತೆ 21(1)(b) ಎಷ್ಟಿದೆ ಅಂತ ಅನ್ಬಿಟ್ಟು.
ಅಲ್ಲ 2 acre 48 cents ಇರೋ ಸರ್, ಎಕ್ವಿಸಿಷನ್ ಆದ 8 cents.
ಆಯ್ತಲ್ಲ, ನಾನು ಅದನ್ನೇ ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇರೋದು, ಅದು ಎಷ್ಟಿದೆಯೋ ಅದ್ ನೋಡ್ಕೊಳ್ಳಿ.
I felt my lord has observed entire land has been acquired
No.
in the order.
No,
Therefore,
yes,
I
yes.
wanted to clarify.
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಲೈನ್ ಬರ್ದು ಬಿಡಪ್ಪ ಶಾಸ್ತ್ರಿಗಳ ಪ್ರೀತಿಗೆ.
ಇಲ್ಲ ಸರ್, ಓನ್ಲಿ ಫ್ಯಾಕ್ಚುಯಲ್ ಮಿಸ್ಟೇಕ್ ಬೇಡ ಅಂತ ಹೇಳಿದ್ದಷ್ಟೇ.
ಆಯ್ತಪ್ಪ.
If it is
ಶ್ರೀ ಶಾಸ್ತ್ರಿ ಆಲ್ಸೋ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ ಲ್ಯಾಂಡ್ ಇನ್ 21(1)(a), 1(b)
1B,
measures totally 2 acres
48 cents.
48 cents, out of which only 8 cents have been acquired by the acquiring authority,
Please.
which is subject matter of reference, and the finding recorded by the trial court that entire land in 21(1)(b) is acquired is thus incorrect, factually incorrect. Full stop. Gazette notification and sale deed of the claimant throw sufficient light on the what is the land acquired, and any contra finding recorded by the trial court shall not affect the claimant number 1, claimant number 2.
Grateful.
Done.